And judges can introduce themselves.
Good afternoon, everybody. My name is Ali Khan, and I am an attorney in Chicago, as well as an alum of the program, participating and representing a national state of Illinois in 1998.
Good afternoon. I'm Dan Taubman. I'm a senior judge on the Colorado Court of Appeals in Denver, Colorado. I'm not an alumnus of the program, but I've been involved with We the People for many years.
And my name is Ben Glickman. I'm a supervisor with the California Attorney General's Office, also an alumnus of the program. I participated on behalf of California at the national finals in 1995. So congratulations on making it here.
And to echo Ben, congratulations, guys. Can you please introduce yourself?
My name is Katie Grammer.
I'm Kayla Parsons. I'm Trinity Goldsberry.
I'm Morgan Mack. I'm Colby Gibbs. I'm Lainey Leeds. We are all seniors here at Laurel High School, and Mr. W is our teacher.
Great, great. So we will be doing question 1 today. So here it goes.
Make sure you speak up, ladies. You're a little far away from the camera. Just make sure you speak really loud.
Okay. I do not think the United States would come to an end if we lost our power to declare an act of Congress void. I do think the Union would be imperiled if we could not make that declaration as to the laws of the several states. What impact has judicial review had on federalism? Is judicial review a counter-majoritarian practice? Please support your position. What limits, if any, would you place on the practice of judicial review? You may begin.
In regards to Justice Holmes' quote, we believe that he was advocating for a stronger general government, seeing that he was convinced that the government would be imperiled if they were not able to declare the law of several states void. Regarding judicial review impact on federalism, we are of the opinion that it has weakened the state's power and has taken away from their individuality. States may feel they have more pressure to follow the federal government's initiatives as opposed to making their own judgments. As a result, one could argue it promotes an imbalance of power. However, some could also argue that unity trumps individuality.
Federalists, specifically Alexander Hamilton, strongly advocated for judicial review, and it was assumed that the Supreme Court would exercise this power when formed. Hamilton stated, if there should happen to be irreconcilable variance between the two, the Constitution and legislation, the Constitution ought to be preferred to the statute. This argument supports judicial review as a basis for a system of checks and balances. It calls into action an approach to determine constitutionality were it ever to be a question. The power of the courts is exercised in not only federal but state courts. Though never stated in any constitution, the Marbury v. Madison case gave a legal standing that judicial review is needed to review cases to determine the constitutionality.
Although it has been debated for years, we do believe that judicial review is a counter-majoritarian practice. Democracy in and of itself is a practice of majority rule with protection of individual and minority rights. As Thomas Jefferson said, that though the will of the majority is in all cases to prevail, if the minority possess their equal rights which equal law must protect, and to violate would be oppression. However, judicial review would be considered counter-majoritarian, since it is a policy that doesn't support individuals enjoying certain rights against the state which will trump the will of the majority. This is an important standard because the United States is built on the foundation of equality of government. And if the legislation didn't have the check of judicial review, that would promote inequality.
While judicial review may be counter-majoritarian, its main purpose is to determine whether or not an act or law passed by Congress is deemed unconstitutional. Therefore, it supports the Constitution and the beliefs inherited from our framers. It is also protecting the minority by keeping the majority in check. If the majority was allowed to just pass laws and act without checks on constitutionality, then the majority may get out of control and pass laws only concerning their own agenda, without considering the constitutionality of their actions. Majority rule has always been an important tenet of democracy, and judicial review could be considered a direct contrast to that. But both can exist as a part of our system of checks and balances.
Judicial review is surrounded by controversy. Yet despite which side you're on, we believe that everyone can agree that such an influential government power expansion policy needs limits to keep it in check, because declaring constitutionality is an important part of the checks and balances between the branches. It's hard to ascertain the limits in place. However, we think that instituting a vote to override major judicial review-driven decisions would keep the balance between the branches. Fixing mistakes can only be done by extreme measures, and that makes it hard for people to voice an opinion on choices ruled by judges.
Judges also have the pressure of the severity of their decision and are forced to take time to think about the impact it will have. Another avenue to restrict the national government's power of judicial review would be to extend that power to the states. If a law appears unconstitutional to a state court, that state should be able to decide if they want to accept the decision or not. If the unhindered power of judicial review were put in the wrong hands, it could cause huge changes for which we are not prepared. The danger of judicial review becoming an unchecked power is an imbalance in the system. If one of the three branches of government becomes too powerful, then we move away from the ideals of the framers. Judicial review has helped change the way our government runs. It has impacted our ideal of federalism by taking away some of the state's power, and it's a counter-majoritarian practice that supports our Constitution's definition of majority rule. It's a powerful policy, but it can be kept in check with limits placed on the overreach of power. We are now ready for your questions.
Thank you very much. The question I have for you guys is you just said a few moments ago about a theory under which extending judicial review to states where they could accept decisions. Did I understand that correctly?
We were, I think, talking, I'm trying to remember what you're talking about, but we know that states have the power of judicial review. I think we were talking more about states accepting the Supreme Court's decisions on judicial review and like more of that relationship and how that works.
So can you maybe just for me clarify, give me an example, create a hypothetical how that would work in your mind.
I think a hypothetical reason of how this would work is that a law comes passed through states courts, and maybe there's a tension between the two sides of a state legislation. They send to their Supreme Court and they decide whether or not they find it constitutionality or not. Maybe there's still a problem with that and they're still having issues. Then it gets appealed up to the Supreme Court, and then they would maybe rule on it. And that's when you would find like kind of a final decision whether or not the state wants to accept that. That would be like how they kind of interact with each other. But first goes to a state level, and then it would appeal its way up to a national federal level.
So basically, the appeal would mean nothing, right? Because if you didn't like the decision in a state Supreme Court, you appeal the Supreme Court, they go the other way, and then the state Supreme Court can decide whether to accept it. Is what you're saying?
I think that I'm trying to explain is that states have the power to nullify any Supreme Court decision. The Supreme Court doesn't have a power, they have no will, and they have no force. So they have no power to say their job is to determine whether or not a law is constitutional. That is their job. But there is no framework or groundwork for states having to accept that. It's their power.
We have seen states today that have nullified against the Supreme Court's decisions with like COVID vaccination cards. Some states say no, they don't want to like enforce those.
I think it's like the power of prestige, like whether or not the Supreme Court is, if they're liked and if they're doing their job and if they have the power of the people backing them up, that's a different thing than if they're not looked upon very favorably. People won't accept what their decisions are.
But isn't that the point though, that they're there to interpret the law? If you on one hand, you're saying they're there to interpret, what's constitutional, but then you're saying ultimately it means nothing because the states can simply say, no, we disagree, sorry.
I mean, ultimately, you come down to it, that's what it is. That their job is to determine constitutionality, but the states always have that power to say, no, we're not going to follow that. We don't think that's right. You think we're overextending your powers, or maybe they think that they're not extending their powers far enough, and we're going to make this a law anyway.
So what existing limits are there on the court's power of judicial review? And do you think any of them are effective?
Congress has limits that they can place by passing amendments and passing rulings that would like nullify the decision of judicial review. That would make that, they can pass amendments that would make that, would change that are different than that. Also, the Supreme Court also has limits through the president can, if they choose, if they come to a decision, that the president can just ignore that decision in a way that he can just choose not to act upon that decision.
They have the null cases, and they also don't take any
Political cases. We saw that very recently when it came down to the 2020 election between President Biden and former President Trump, that there were many states that appealed to the Supreme Court to overlook that decision. And we saw that they refused to take those cases. They refused to rule on them. So I think that's some limits that they have put on themselves for the judicial review.
So you mentioned in your opening statement that Thomas Jefferson thought that judicial review was a way to protect minority rights. Can you give us some examples of the opposite, where the Supreme Court has decided cases that have not protected minority rights?
So that's a tricky one. I think we mostly focus on how they protect the minority rights. I think, I know this isn't answering your question, but I think like in Brown v. Board, very minority, protecting the minority rights, protecting the Black rights, protecting their education. I think that's a bigger thing. And I'm sorry,
Is there another case? Can you give us another example besides Brown where the Supreme Court has protected minority rights?
There was a case, it was Harper versus the Virginia Board of Elections. And basically Virginia Harper could not afford to pay the poll tax, and so they would not let her vote. And judicial review helped take away the poll tax. They declared that the poll tax is unconstitutional and therefore allowing her the right to vote.
An example of today that's actually going on currently would be the transgender athletes. And we actually in Montana on Tuesday, April 20th, passed HB 1112 that prohibited the transgender athletes participation in their sports. And so that is also a big issue that's going on that's protecting minority rights. And as you can see, it's also another example of nullification between the states, as some are nullifying the Supreme Court's decision and others are going along with it.
And to add on to that, 5 other states other than Montana have passed that law saying that transgender women cannot compete in collegiate sports. And West Virginia passed that law on Tuesday the 6th, and it was HB 3293. Tennessee, Texas, Arkansas, Mississippi, and North Dakota have also passed those laws.
I think that,
How does that relate to the Supreme Court? I know that several states have passed those laws, but is that counter to an existing Supreme Court decision, or is that just an issue that the Supreme Court is likely to have to weigh in?
I'm sorry, I kind of interrupted you, but I think that's an issue that the Supreme Court is likely to see in the future, because I think it's going to become an issue of states versus states. I know that the NCAA has threatened that no tournament games will be held in states that prohibit transgender athletes. And so I think that it's going to be a case that the Supreme Court sees. And I think with the way that we have the way it's set up with the 6 conservatives versus the 3 liberals, that it's probably gonna vote in, no, they're not gonna be allowed to. But I think that's just because you see the way when judges are elected, I'm just telling you my words, the judges are elected, that you can see the way they're going to vote by the person that appoints them. I think that's something that is really happening now, but even was happening back in the 1800s by who was appointing judges. So I just think it may not be something they've already voted on, but I think it's definitely a very important candidate for something that's going to happen.
Okay. Well, let me ask you guys this. Do you think that Supreme Court justices should be term limited?
We do as a panel believe that they should be.
Why?
I believe that the longer they're in office, the more opinionated they get. And
I think we've had a very big discussion about this actually as a group. And we see like with presidencies, the terms are shortened as they don't focus on their own opinions. They go more towards pleasing the people so that they get reelected the second time or, not.
Okay.
I think that
Well, I'm sorry to cut you off. We're out of time, unfortunately.
okay.
Thank you very much.
Round of applause for the students for a great job. And now the judges have some feedback.
Sure. First of all, thank you again, and congratulations for being here. I know it's not always easy to be on the other side, so congratulations. One thing I want to point out, I really liked the way you all participated. I think that's great. Keep that up. The one thing that I guess I was kind of questioning that I want you guys to think through a little more, just to have answers if you believe this should be the case, is to be able to kind of answer questions that are contrary to your position when you talked about the scenario where a Supreme Court decision is X, that is contrary to what a state Supreme Court said, and give the state Supreme Court the ability to essentially nullify that, the impacts of that theory, what can that cause? Just heavily fleshed out, because that's, I think it's kind of a controversial position. So make sure you're able to kind of understand what people who don't agree with you are coming from, and to be able to address any concerns they may have.
Okay.
Thank you.
Ben, anything you want to add to that?
Sure. Yeah, I would agree with that. I thought the prepared remarks did a nice job of answering the question. I appreciated the kind of the history that you started off with, beginning with what the Federalists advocated, et cetera. And then I liked your approach to the counter-majoritarian piece. If I understood you correctly, what you were saying is, yes, it's counter-majoritarian, but it protects minorities, and that protection of minorities itself is part of America's constitutional legacy. And so therefore it's okay that it's counter-majoritarian. In other words, it supports kind of the broader democracy that America has fostered over the years. And I kind of like that. I think at one point you said both can exist. And I kind of like that framing of that. So I appreciated that. On the question about limits on the Supreme Court, I thought you guys did a pretty good job there. I particularly appreciate it, and I wish you had gone more into, you mentioned political questions and these kind of self-imposed limits on the court. And of course, there's many more, right? There's the mootness doctrine, standing doctrine. All of those things are things that the court has done to itself. And you have to ask yourself, well, why would the court limit its own power? And it's doing it because of everything that this question is about, because it's counter-majoritarian, because it lacks that enforcement of power, because it's dependent on the states and the president and everybody else following its decisions. It's going to be restrained in those decisions to ensure that it maintains that legitimacy. And so I think a little bit more might have tied in all of these big concepts together, and it would have been an even stronger answer. But nice job overall, and congratulations again on making it here.
So I just wanted to add a few comments. I agree that your beginning presentation was mentioning Alexander Hamilton, and the Marbury v. Madison was good. I think you might want to think a little bit more about your idea of saying the states should be able to decide whether to accept the decision of the Supreme Court. Because if you think about it, that means, like, if the Supreme Court says that same-sex marriages are okay, that any state could say, well, we don't like that decision, so we're not gonna follow that decision. And so that could create a situation where one state allows same-sex marriage and another state doesn't allow same-sex marriage. And then what would happen if a couple was the same sex were married in one state and then went to a state that didn't have same-sex marriage? That could be very complicated and difficult to figure out what to do. The one other comment I have about your support of term limits is that people say that there shouldn't be term limits because of what's known as the doctrine of judicial independence. That means that judges are not going to decide at all based on their political views, because they're in office as long as they want to, or as long as they live. And so that way they're more free to decide the cases the way they think they should be decided, even if their decisions are unpopular. So that's the other side of the discussion about term limits. So that's something that you might want to think about. But I'm glad that you spent time discussing the issue of term limits, and it's clear that you are familiar with all of the different parts of the question that were asked, and I think you did a nice job. So congratulations.
Thank you.